Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about criminal trespass. Every individual has a right to the full enjoyment of the property without any disturbance. That is the reason trespass was made an offense. Even though trespass is ordinarily a civil wrong for which the defendant can sue for damages, but when such trespass occurs with a criminal intention, it amounts to criminal trespass. If your enjoyment of your property, whether movable or immovable, is disturbed due to criminal activities of any kind, be it theft or assault, you can seek remedy under the Indian Penal Code. For instance, X unlawfully and without Y's permission enters into Y's house to steal his grandfather's antique watch. X would be liable for theft as well as criminal trespass. Further, the offence of criminal trespass may be aggravated depending upon the facts of certain cases. Consider the same example with an additional fact that X entered Y's property at night, or in order to enter the assaulted Y, then X would have a greater liability. As the subject of criminal liability is so vast, the Indian Penal Code has discussed criminal trespass in 22 sections commencing from section 441 IPC till section 462. Meaning of criminal trespass. According to section 441 of the Indian Penal Code, whoever enters the property in the possession of another with the intent to commit an offence or intimidate, insult or annoy any person in possession of such property or having unlawfully entered into such property, but remains there with intent thereby to intimidate, insult or any such person, or with an intent to commit an offence, is said to commit criminal trespass. Thus, it can be deduced that criminal trespass occurs when a person unlawfully, without any right or an express or implied license, enters into the private property of another person or remains into such property with a criminal intention. The object of making criminal trespass an offence is to ensure that people can enjoy their private property without any kind of interruption from outsiders. Punishments for criminal trespass as prescribed in section 447 of the IPC is either imprisonment, which may extend to 3 months, or fine, which may extend to INR 500 or both. Ingredients of criminal trespass. Criminal trespass has two limbs. Firstly, entering into the property of another with criminal intent, and secondly, entering lawfully but remaining in the property with a criminal intent to harm or cause annoyance. Thus, the essential ingredients for committing criminal trespass are: whoever enters. To commit the offence of criminal trespass, there must be an actual entry into the property of another by the accused person. No trespass can occur if there is no physical instrument by the accused into the private property of the victim. In the state of Calcutta versus Abdul Sukar, the court held that the constructive entry by a servant does not amount to entry. Under this section, as even though there was a possession in law, there was a possession in fact. For instance, X throws a garbage outside Y's house on a daily basis. In this case, X may be liable for nuisance, but he has not committed criminal trespass as there is no entry by X into the Y's property. Property. The term property under this section includes both movable and immovable property. Wrongful entry into one's car or other movable property would have similar liability as a wrongful entry into one's house. In Dhananjay versus Provat Chandra Biswas, the accused drove away from the board of the possessor after attacking him. The court held that this would amount to criminal trespass even though it was a movable property. But the term property does not include incorporeal property or something which cannot be touched, such as patent rights. Possession of another. The possession of the property should be in the possession of the victim and not the trespasser. Having the ownership of the property is not necessary. Mere possession is sufficient to claim criminal trespass against the trespasser. However, it is not necessary for the person having possession or the owner of the property to be present at the time when the trespass occurred. No presence of owner or possessor would also amount to trespassing as long as the premises are entered into by the trespasser to annoy. For instance, writing love letters and delivering them to a girl's house against her will would also amount to criminal trespass, even if at the time of delivering such letters the girl was not at home. Intention. If it is provided that the intention of the accused party was not to insult, harm or annoy the owners or possessor of the property, then it would not amount to criminal trespass. The intention is the essence of this crime, and if there is no dominant motive to commit the crime, no criminal trespass. The test for determining whether the entry was done with an intent to cause annoyance or any kind of harm is to determine the aim of a trespasser at the time of such entry. In Punjab National Bank Limited versus All India Punjab National Bank Employees, the court held that as the employees who were on strike entered the bank with the intention to only put pressure on the management to concede their demands, and there was no intent to insult, harm, or annoy any of the superior officers, their entrance into the bank account cannot amount to criminal trespass. However, if in the given circumstances the striker would have stormed into the private cubicles or offices of the superior staff with the aim of causing annoyance to such members, then it would amount to criminal trespass. Thank you.